Bioethics 2.0, Podcast Episode 7, Privacy and Confidentiality. Bioethics 2.0 Podcast, Episode Guide. This is Podcast Episode 7, regarding privacy and confidentiality. You can find this information in Introduction to Clinical Ethics by Fletcher, Chapter 7. Additionally, this information can be found in Schroeder's Practical Ethics for Nursing and Nursing Students, a short reference manual, Chapter 6. Privacy.
This section of the podcast is about some of the differences between the concepts of privacy and confidentiality. The right to privacy is a basic and fundamental human right. Privacy is integrally related to our own personal integrity. It is a form of personal autonomy, which is the ability to control information that others have about us.
Confidentiality as a negative right.
Confidentiality is the process of keeping secret, intimate knowledge that a patient has entrusted to a clinician. Confidentiality protects the patient from harms that may be caused by releasing intimate data that has been disclosed to or observed by the clinician. Some of the philosophical underpinnings of the concept of privacy and confidentiality have to do with the notion of negative and positive rights. A negative right is the right of non-interference, the right to be left alone. It is a basic prerequisite of self-determination and moral agency.
Privacy as a positive right.
In contrast to the negative right is the positive right to privacy, which involves a person's prerogative to control access to and distribution of information about him or herself to clinicians. About confidentiality.
Confidentiality is one of the mechanisms by which a person's right to privacy is recognized and honored. It reflects the premise that individuals should exercise control over certain information that pertains to them. Essentially, this information is their moral property.
What is confidentiality?
Confidentiality is a form of promise that is based on a trust relationship. Without the presumption of confidentiality and its underlying foundation of trust, true intimacy between persons would not be possible, nor would a quality clinician-patient relationship. Why is confidentiality important?
Nurses safeguard patients' right to privacy by protecting information of a confidential nature. Also, the nurse safeguards the patient's right to privacy by judiciously protecting information of a confidential nature, because without such assurance, the patient might be unwilling to divulge information critical to his or her care.
The basis for the principle of confidentiality.
Confidentiality respects the individual's privacy and autonomy, and it builds the special trust inherent in a nurse-patient or physician-patient relationship. The confidentiality agreements between such authority figures is also good for society and prevents harm to the patient. Exceptions to confidentiality.
There may be legal exceptions to confidentiality that necessitate divulgence. These include testifying in court, reporting communicable diseases, reporting child abuse, spouse abuse or elder abuse, reporting gunshot or suspicious wounds, or reporting for workers' compensation cases. Nurses are also required to report gunshots or suspicious wounds if there is a reasonable cause to believe that the wound occurred as a result of a crime. Why would a nurse breach confidentiality? When is it acceptable to breach confidentiality?
It's morally acceptable to breach confidentiality in the following situations: when there is a high probability of serious physical harm to a person, or if a likely benefit will result from breaking the confidence, such that harm can be prevented to oneself or others. The breach of confidentiality must be a last resort, such as when persuasion and other approaches have failed. Or lastly, the breach is generalizable. It is reasonable for a nurse or doctor to breach your confidence and to treat you in the same way if you were the patient. There may be situations in which there is an ethical demand for the nurse to consider breaching patient confidentiality. Such a problem may occur, for example, when a patient who is HIV positive refuses to tell his or her spouse or significant other of the infection, thus placing the other at risk of contracting a lethal disease. The nurse who is aware of this situation is in a bind between the duty to the patient and the stronger ethical duty to warn an unsuspecting person of significant danger. Such a breach is justified when all of these conditions apply.
The duty to warn. Tarasoff rule.
There is a fundamental ethical and legal duty for clinicians to initiate what is called a Tarasoff warning. This duty comes from a 1974 legal case in which the duty to warn third parties who are at risk of injury by a patient was established in the case of Tarasoff versus Regents of the University of California. Judge Marshall wrote a very interesting quote to denote when the differences between the negative and positive rights to privacy and confidentiality exist. Marshall said, quote, "The protective privilege ends when the public peril begins."
Ethical and legal criteria to initiate a Tarasoff warning.
Several criteria must be met in order to initiate a Tarasoff warning. The first criterion is when violence is foreseeable. This has to do with the actual background of the Tarasoff case. A student at the University of California told his psychologist that he was going to murder his girlfriend, Tatiana Tarasoff. So, when a clinician believes that violence is foreseeable, that is a situation with ethical and legal justification to initiate a Tarasoff warning. Violence being foreseeable is determined by three factors. First, when there is a known history of violence. Second, when there is a threat to a named or clearly identifiable victim. And third, when a plausible motive exists. So if two of these particular factors exist, the standard is met and a clinician may initiate a Tarasoff warning. There is a legal and ethical duty to break confidentiality and warn the imperiled third party. If only one of these factors is met, it is really a situation where you could go either way, and clinicians should get ethical and legal guidance in terms of initiating a Tarasoff warning. The other criterion that is very important is that the clinician has to have enough control over the patient to prevent the violence, such that the patient is in an institutional setting or can be committed to an institution to make sure that they don't commit violence.
How far does Tarasoff extend?
Although the case was tried in California, this is an instance where the legal case has helped determine what the ethics is or should be, and the principles from Tarasoff have been extended to the general United States healthcare setting and are widely acknowledged in bioethical and legal discourse. The question becomes, however, under what circumstances is it acceptable or permissible to violate patient confidentiality to protect someone else or the public good? And this is the ethical dilemma that clinicians are going to need to grapple with to determine how far Tarasoff can extend to their general practice. What about electronic confidentiality?
As more patient records are maintained electronically, nurses must be more diligent in ensuring confidentiality of those records. Today, a nurse must be careful not to allow patient information to be publicly visible from a computer screen.